This time Bobichin answers first, I believe. Article 1, Section 15A of the Virginia Constitution sets out that marriage in Virginia is the union between one man and one woman, and only that is valid and recognized by the Commonwealth. And in fact, that no, the Commonwealth or any of the political subdivisions shall not create or recognize any legal status or relationship of unmarried individuals that intends to approximate that, nor shall the Commonwealth create or recognize any other union, partnership, or other legal status to which is assigned the rights, benefits, obligations, or effects of marriage. That's the law of Virginia. Now, we have a case that's before the Supreme Court right now, according to the question from the audience, is to explain your legal opinion with respect to the questions that are before the Supreme Court. California Prop 8, which is presumed to define marriage in California. And I'll add one more question, since Mark, and you're answering first. Okay, so never mind what happens in the Supreme Court. You're now the Attorney General of Virginia, and gay Virginians come to you and demand the equal rights under the law, to be treated equally under the law, to have the same rights, obligations, and responsibilities, and the same ability to marry just as anybody else would as a citizen of the Commonwealth. What are you going to do?
I believe that marriage is an institution to be entered into by one man and one woman. I support Virginia's marriage amendment. I supported it, and I continue to support it.
Yay!
I believe that Virginia's marriage amendment is constitutional. I do not believe that there is a basis for challenging the constitutionality of Virginia's marriage amendment, and I would not have a moment's difficulty in standing up and defending it in court. With that being said, I want to make it very clear that it is critical for us to stand up to protect the rights of all Virginians. The marriage amendment does not create discrimination. It does not. It deals with the recognition of an institution called marriage. But we need to make sure that Virginians' rights, their privacy, is protected. And there is nothing in the marriage amendment that addresses or prevents people from entering contracts with one another, signing wills, leaving property to one another, buying houses and owning property jointly, signing advanced medical directives, and designating the person of their choice as the grantee of the powers under an advanced medical directive. We need to make sure that we protect the rights of Virginians not to be subject to discrimination on any inappropriate basis in the conduct of their daily lives, in the conduct of their businesses, in any inappropriate ways. Now, we need to make sure that that is not institutionalized. Do I support creating an independent cause of action? No, I don't. I think that employers need to be protected, and we need to make sure that we achieve that appropriate balance.
Saved by the sign. Rob?
Well, I voted for both the statute, the law in Virginia that made it one man, one woman as marriage, and I voted for the constitutional amendment, and I voted for it when it came out. And this issue is not directly before the Supreme Court, but I think everybody understands that it could be. In other words, if the Supreme Court takes an expansive view of the cases in front of it, it can do one of three things. Number one, it can use a procedural hurdle to strike down the California Prop 8 and nothing else. There's actually an issue about whether the person who is defending it has standing to do so. If the court wants to be very, very narrow, they can rule on that basis. The second is they can address DOMA, the Defense of Marriage Act. That's the federal act that does two things. First, it says that states are not required to recognize another state's marriage law if it has something other than one man, one woman. It also says that federal law, for purposes of federal benefits and other issues, will be one man, one woman. They can strike that down as a federal issue and leave it on a state-by-state basis. Or they can take the most expansive ruling and say, we no longer believe under the United States Constitution that you can have a marriage law that specifies one man, one woman. Those are the three possible outcomes. Everybody who's watching this believes it hinges on one man's decision, Justice Kennedy, will make his mind up sometime in the next 6 weeks and thereby set social policy for the entire country. And anybody thinks this is what the founders intended or how this is supposed to work, they're out of their minds. This is not, and in fact, Justice Kennedy has said that. He has said, we do not make these decisions best when we let the court do it. I'm aware that there is substantial discussion about this issue. You have, I think it's up to 9 states now that have some form of this, some form of gay marriage. Virginia does not. The proper way for this to be addressed is through the political process. Somebody who's smarter than me can predict where we will be in 50 years, but that's the proper way to do it, not to have the court make these decisions for us. Thank you.
So to follow up, Mark, it is your position that marriage is not a right that applies equally to all Virginians with regard to sexual preference?
You know, there's something called substantive due process, in which courts substitute their policy judgments for the judgments of the legislative branch. It's been happening for an awfully long time. And it is important for us to fight back, to pursue a judiciary that sets aside, as the federal judiciary gives lip service to setting aside this notion of substantive due process. No, I don't believe that it is illegal or unconstitutional for the state legislature to adopt a statewide policy defining the institution of marriage. And I do not believe that the Supreme Court should strike it down. I do not believe that it will. However, I was kind of wrong about Obamacare. And I hope that the Supreme Court decides not to substitute its policy judgment in this instance for the judgment of the various states.
So, Rob, your position is that marriage is not a right that applies to all Virginians without regard to their sexual preference.
But I don't think it's up to the court to make this decision. This is not the role of the court to act like another political body. We have an executive branch, either the governor or the president. We have a legislature that sticks its finger up in the air and says every 2 years, what do the people want? We don't need a third. We don't need a court to say, golly, the polls seem like this, or there's 9 states that do and 41 that don't. The court's job is supposed to be to interpret this. Is the law constitutional or not? That is supposed to be the role of the court. And where you see where they have gone astray is when they're thinking too hard like politicians and not enough like constitutional analysts. That's when they get in trouble. So the most corrosive decisions they have had, and we might have a disagreement about which those were, but the most corrosive decisions they have had is when they were untethered from the Constitution and just said, people seem to be headed that way, people seem to be moving that way, we'll just get there a little faster.
Yeah.
Now, I had the great privilege of studying under some of the best constitutional scholars at the University of Virginia. I just had blind luck to have them. They were terrific, but here's what they pointed out. If the court was so brilliant, if it could always figure out what the Constitution meant, it wouldn't wait until the public almost got there before it changed the law. You wouldn't abolish the death penalty in 75, you would have done it in 1842. But somehow they got there only when a bunch of other states were moving that way. They wouldn't have taken up abortion in the late 60s and early 70s. They would have done it in the 1920s. Why do they get there? Because that's where the public has almost gotten to, or the public's about to get to. That's all the court does when it tries to divine what the politics ought to be. That is not the court's role. It's our role, for better or for worse, so that there's accountability. And if you want to change something, you change the politicians, and they change it for you. We don't need a court to do that. Thank you.